All rise. All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have one case on the calendar this morning. It's 22 CV 332, DORIS CHIBIKOM you're going to correct me, counsel, about my pronunciation, versus the District of Columbia et al. Counsel, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Good morning. My name is David Branch, and I'd like to reserve 5 minutes for rebuttal.
And the pronunciation of your client's name?
CHIBIKOM.
CHIBIKOM.
Good morning. I'm David Branch. I represent the appellant DORIS CHIBIKOM. There are at least 3 issues in this appeal. This is an appeal from a grant of summary judgment from the DC Superior Court. The district court granted summary judgment on Ms. CHIBIKOM's claims of discrimination based on national origin and retaliation under the DC Human Rights Act. The first issue for the court is there was some concern raised by the trial court below on whether there were actually adverse actions taken against Ms. CHIBIKOM. The Supreme Court has made it clear just over the last week that if there's action that causes some harm, then that action satisfies the requirements of Title VII. Of course, since the DC Human Rights Act, the interpretation of the DC Human Rights Act follows the interpretation of Title VII, that should be applicable here as well. And that's the Muldrow v. St. Louis case that was issued, I believe, on April 17, 2024. So Ms. CHIBIKOM was a service coordinator for the Department of Disability Services. There were a number of actions taken against her in the 2016-2017 timeframe. There were at least 4 employment actions. First, she was denied overtime. Then there was an issue with Ms. CHIBIKOM being issued a 9-day suspension. There was also a failing performance evaluation and placement on a performance improvement plan. The trial court erred in resolving these issues for these different actions because the trial court weighed into the factual dispute, and in particular for the 9-day suspension. There was evidence presented that the same offense that Ms. CHIBIKOM allegedly engaged in, and that was submitting a retroactive service request within 60 days of the request being made. There was evidence that another individual performing essentially the same job submitted a service request, retroactive service request during the same period of time. So the trial court weighed.
I thought the trial, the trial court looked at the facts and said, okay, you've got your comparator, you've got this one other employee who submitted one retroactive request. But the government's argument is your client submitted multiple retroactive requests and not retroactive by a de minimis amount, but by, a couple of months. And that's extremely costly to the district government because they're picking up the tab since Medicaid won't pay, or Medicare. My apologies if I'm getting them confused.
Medicaid, I believe.
So the court said that's not a valid comparator there. That's what the court said. It wasn't resolving any sort of factual dispute. It was saying, you want to show discrimination, you've got to show an actual comparator here, and you don't have one.
Well, Your Honor, I believe there's evidence in the record that Ms. CHIBIKOM and all staff were informed, I believe it was in May of 2017, that these type of requests could be submitted up to 90 days after the request was made. And she was operating under the information that she was provided at that time when she submitted the request. But when you get to the point of you're parsing through the degrees to which someone's compliance, even if we accept your rule as a rule that should have been complied with, when you get to the point where you're comparing someone's, the extent that they complied and weighing whether doing it within the first week should result in no penalty as opposed to doing it within 60 days should result in a 9-day suspension. That's an issue we believe that's beyond just a legal determination. That's something that should be decided and tried by the the finder of fact by the jury.
So, sorry, your argument then is the record shows that they were told that this was okay, that the employees were told that this was okay, or that your client was never told that it was not okay? And what did the trial court say about that?
I don't recall exactly if the trial court actually addressed that specific issue, but I know that
Was the argument raised to the trial court?
was the argument raised to the trial court
The
on
one that you're
whether.
making, the one that you're making right now, that this was okay up to
Yeah,
90
that it was, that
days.
was the practice that was followed throughout the office.
Right, but in the argument of the summary judgment motion, was this argument made to the trial court?
I think we made the argument before the trial court that she was complying with the guidance in the office as she understood the guidance. And I do recall that there was a citation to, I believe it was a meeting or an email where it was permitted to submit these requests within a period of 90 days. And then on to the other items that she identified, the denial of overtime. That's again, an issue we believe was improperly decided by the trial court. She made a request that she was working beyond her regularly scheduled period of time. She made a request for overtime. She made an allegation that, well, her overtime was denied. That's not disputed, but she made an allegation that others were approved or granted overtime under similar circumstances.
And this was discussed at length at oral argument on the summary judgment motion. And what the trial court said is, look, there's evidence in the record that the overtime was, or that no one ever got overtime for regular work duties, right? That there was one instance when there was a snow day or something when people were given overtime to catch up, but that to fulfill your regular work function, you didn't get overtime for that. Right?
Yes, I recall that. Yes, that was part of the record.
So, I mean, don't you have to show that that's protectual? Do you have any evidence counteracting
I think that
contradicting?
was the argument that was advanced by
Well, that was the
district.
evidence. That was a witness testified to that, I believe.
Yes, and Ms. Chibikom's position was that there were instances where other employees were.
But did she
approved for
put
overtime.
forward any evidence of that being the case?
The evidence that she offered was just through her own testimony, I believe.
Any specifics? I mean,
But why is it pretextual if there's a policy that we don't give overtime to people for doing their regular job
If it's applied
at
in,
all? I mean, how is she treated differently than anybody else,
If-
except for people who are on maternity leave and things like that?
well, yes, Your Honor, if it's applied in a discriminatory manner, and that's her assertion that it was applied in a discriminatory manner, that she was doing her regular duties for whatever reason. She's out in the field doing work, and for whatever reason, she needed to request overtime to complete whatever assignment, and the request was denied. There's also evidence in the record of just comments. I mean, there's some direct evidence in the record where the supervisor is telling her, I don't understand your English, or I don't understand what you're saying. All of this implying some type of national origin discrimination. I don't understand what you're saying. Take an English class. I think there were at least 2 supervisors who made discriminatory comments to her based on her conversations with those supervisors at different times. There's also an issue, and as it relates to the retaliation claim, the trial court also granted summary judgment on the retaliation claim. And the court found that that she did not engage in protected activity, but we have several instances of protected activity, from filing multiple EEO complaints against these supervisors, including one supervisor, I think Mr. Kaufman, because he made comments to her about taking an English class, and I don't understand what you're saying, as well as she engaged in EEO mediation to try to resolve the complaint, and then she actually filed a complaint in court naming the defendants, the district as a defendant, as well as the individual supervisors as a defendant.
Yeah, I mean, I think you have a point. The trial court probably mucks that up, that that's not protected activity. She's making complaints of discrimination. They don't seem wholly unfounded, even though the trial court found they were not substantiated. But it kind of runs into the same problem with your discrimination claims of where's the evidence of pretext? They've given, you know, a really pretty compelling explanation for what is not so serious an adverse employment action. A 9-day suspension, granted it's serious, it's quite short of a termination though. And their explanation is your client has done something 4 or 5 times with no explanation other than that she forgot to submit timely requests, or she was too busy to submit timely requests. They're quite costly. That just kind of on its face looks like something that requires some adverse action if you're an employer. And I don't know, you might have a protected activity, and it might be close enough in time to give rise to some inference of retaliation. But when they come back with what seems like a very legitimate reason for the 9-day suspension, I don't know what evidence I could look at to think, actually, this was national origin discrimination. So what evidence do you want me to think about? Is it that some statements were made to her that they didn't think her English was good enough?
Your Honor, there are a couple of things. One, yes, statements made against her, plus how she's being treated during this entire period of time. All of this, we've described it as a pattern of antagonism, but also
I mean, that sounds like a hostile work environment claim, but I don't think you've challenged the trial court's ruling on that, have you?
Yeah, we didn't challenge the trial court's ruling on the hostile work environment claim, but this is still a factor that can be considered in in determining whether someone is engaged in employment discrimination. I think an important point is that she was operating under the guidance that she had at the time. I believe I mentioned earlier that there was either a meeting or an email where she was told that it's permissible to submit these requests within 90 days.
If you could point me to that. I was looking after you said that and I didn't see it. So where do you think that is in the record? Maybe in your rebuttal, you can point me to it. I don't recall that.
Address that.
But you know, your brief on retaliation focuses virtually 100% on the suspension. And it was previously shown, let us say, that there was no pretext involved in his suspension. So how does your retaliation claim work? I mean, what arguments are you bringing up? New arguments now as to?
No, I'm not, Your Honor, I'm not bringing up new arguments, but I believe the Supreme Court has made it clear that any of these actions would constitute an adverse action. I think in the Muldrow case, it was someone who was transferred and there was discrimination or retaliation in the transfer. And her position has been that the retaliation was, yes, the 9-day suspension, but the retaliation was also all of these other acts that took place that were taken against her after she.
I understand all that, but what I'm asking is, we normally review things on the basis of arguments that are made in the briefs. And what I'm asking is, it looks to me from your brief that your fundamental retaliation claim is based upon the 9-day suspension. At least that's what you talk about. And that issue, it seems to me, is the same issue as whether or not there was pretext in the discrimination claim. And that if there's no pretext in the discrimination claim, I don't see how there can be discrimination or rather retaliation in the Because the issue has sort of been, it's the same issue, isn't it, of pretext? In other words, for retaliation, you have to show the same pretext reason as you do for discrimination. Isn't that correct? Or is the standard different?
No, I believe
I
this,
think it's the same
yeah,
standard.
this, I'm not disputing that. The standard is the same, yes.
Okay.
All right, council, it looks like you have exhausted your time, so I'm going to let you sit down and we'll hear from the government.
Good morning. May it please the court, Lucy Pittman on behalf of the District of Columbia and Greg Kaufman. I'm going to start actually where council started, which is the adverse action definition. While that has somewhat changed in Title VII for discrimination, it has not changed for retaliation. The standard remains the same. So I just wanted to quickly mention that before moving on to the discrimination claims here. So as the court has already discussed, the district has a legitimate non-discriminatory reason for the suspension. It is our position that the suspension is the only issue that has been briefed on the discrimination claim, and that these other issues have been forfeited. I'm happy to discuss them if the court wants me to, but I am going to focus on the suspension, which is the subject of his brief, or of her brief, I'm sorry. And so the court's already identified what that legitimate non-discriminatory reason is, which is 5 egregiously late service requests. In order to get an inference of discrimination, there would need to be a similarly situated comparator. There isn't one. The one request that appellant has pointed to is the Bram request. And I can point the court to that if they need that. It's in the supplemental appendix at 186. It's a one-off late request. I'm going to put in quotation marks that it's Bram's request, because we actually learned from Brown's testimony that this is actually a 6th late request of appellants. And you can see that because Bram, who was not similarly situated because she didn't have the same rank as appellant at the time, she was a supervisor. She became a supervisor in October of 2017. And when this late request came up, it was in December of 17 to January of 18. So they didn't have the same rank, which makes them dissimilar. And the misconduct is also not a match, which makes them dissimilar. And then we have the added factual issue, which you do not need to decide it on, but I think it is probably important to note, which is that it's actually appellant's 6th late request.
Is it true that you need a comparator to make out a discrimination claim? Like what if the reason that were offered were so clearly pretextual? Like, let's say you wore blue shirts to the office and nobody else wore blue shirts to the office, and we're going to terminate an employee for wearing blue shirts. That's their story. But there's some reason to think, that they fall in a protected class. There have been some comments made to them about that protected class, so that one really just can't credit that reason. And you might say, well, that's just got to be a pretext for something. It's too impossibly stupid to be the real reason. But there's no comparator because they found a thing and nobody else wore blue shirts to the office. Is that right as a matter of law, that you need a comparator to make out a discrimination claim?
There's 2 ways to make out a discrimination claim. One is to have discriminatory animus. That is not how this was litigated. This was litigated as the comparator case. So that's the option that she chose. I will say we got a little hint of what a discriminatory animus claim could be during argument, which would be new and not something that can be raised, which is the English language classes and comments. I'll simply note that's not how this case was litigated. So obviously there isn't all the full discovery on that. It's also from 2014. So it also then runs into the problem of the Superior Court saying all of the things that occurred before 2014 are not part of this claim. And I would just point out, for the court's comfort, we know exactly what Mr. Kaufman thought about her communication skills in 2017. He wrote it in his evaluation, and that's in the supplemental appendix. And he said that she communicates well orally and verbally, or verbally and in writing. I'm sorry. And so I don't really, the biggest problem there is that it just wasn't litigated that way. And so we don't have the full evidence. If we did, and this is outside of the record, and I fully acknowledge that, the recommendation in her evaluation in 2014 was to take a professional writing course, not an English course. But again,
Can I ask, do you know what he's referenced, your opposing counsel has referenced a couple times an email that said these requests could be submitted up to 90 days. I don't recall seeing that. Do you know what that might be in reference to?
no,
Do you have a guess as to what he might come up here with on rebuttal and point me to? No?
I have no idea. I can simply point to brief page 8 of appellants in which she acknowledges she knows that the policy was announced in the spring to have these done timely. I don't see anything in the brief or the record that gives 90 days. That would be very contrary to everything that's in the record. And I will say that before the Superior Court, before Judge Ross oral argument, that 90 days was not raised. What was discussed there was not that she didn't know the policy against late, but she didn't know the consequence. That's very different.
Right.
And certainly that doesn't give you pretext. So I'll move on quickly to the retaliation claim. I completely agree with Judge Stedman. The only thing that's preserved here is the 9-day suspension. And there again, we have the legitimate non-retaliatory reason for the suspension. We do not have pretext evidence. And we also have, I think, some pretty big causation problems. We'll start with there's nothing in the evidence, no evidence in the record, excuse me, that Mr. Kaufman was even aware of these purported protected activities.
Well, I mean, I don't know if I would start there. There was evidence that he knew at the time of his deposition.
Mhm.
Nobody clarifies when he gained that knowledge. And I think under a preponderance of the evidence standard, given that there was an HR meeting in June of 2017, almost inevitably, I think he would have been questioned about that, or one could reach that conclusion. So there's not, yes, I knew about it then, but there is a statement that he knows. Nobody seeks clarification. Which way does that cut on a preponderance standard? I don't know. My guess is that he probably knew about it. That's not, I know you might say, well, the word guess is in there, so that's speculation. No, we make informed choices all the time based on like the best evidence in front of us, and it just strikes me as more likely than not. Do you think that's faulty?
I do, and here's why. Because it rests on this, well, he had to have known, and courts have consistently rejected that. There has to be.
It's not that he had to have known, it's that he knew.
No.
He knew at the time of his deposition.
Correct.
And nobody bothered to drill into that. And it can't be that every uncertainty goes in your favor. Like things, what if they nailed it? What if they got the date one day wrong? And they got an admission from him that he knew the day after he suspended her. They meant to ask whatever the date of the suspension was. I don't recall, October 10th, I think, 2017. But instead they said did you know on October 11th that she had made this? It says, yes, I knew. You think they would not have made out a claim because it would be too speculative to say it? You also knew on October 10th?
So a couple of things on that, and then I'm going to turn to the rest of the causation issues. One is the courts do reject the must have known, and I'm putting that in quotation marks because that is the language, type of speculative statements because it's not evidence. And here it is her burden. She needed to ask during deposition, when did you learn? And instead we have at the argument before Judge Ross, counsel fully admitting that he said it in the present tense and that they didn't actually know. When asked by Judge Ross, show me the evidence in the record that Kaufman knew at the time, the response was, quote, the agency knew. That's not evidence that Mr. Kaufman knew. But turning to the other causation issues, there's two ways in which you can get you can establish causation. Temporal proximity is one. Here we have 5 months between the first purported protected disclosure, May, and the October recommendation for a suspension. That's not close enough in time. We know that from this court's cases in Johnson and Taylor,
and
4 months and 2 months are not adequate.
And you're going to well, I don't know if we've ever drawn such a hard line, but in August, you're going to tell me that because it didn't use the word discrimination, the complaint in August didn't bring it close enough in time?
Oh, the August is definitely not a protected disclosure. There's nothing in the August complaint that comes close to falling under the protection of the Human Rights Act. It is a complaint about a disagreement that appellant had with HR individuals about whether she took a file from a desk. There is just no factual connection with that dispute and anything related to the things that the Human Rights Act protect. And so we are looking
I
at
guess-
what I think is probably the closer call to May. I don't know that that's a protected disclosure, but for purposes of our discussion right now, let's assume that it is. That's 5 months. And this court has been very clear in Taylor that 2 months without something more, some other positive evidence to get you sort of the causation, that's not sufficient.
I guess I'm wondering whether, do we take each complaint piecemeal? I mean, are we not allowed to look at the other complaints that are happening kind of around the same time to say, I mean, look, there's sort of a pattern of complaints, and in some of them, she says discrimination. In the one where she talks about the file, she doesn't say, look, I think they're pointing at me for taking the file because of who I am. She doesn't say that, but clearly she feels persecuted is probably too strong a word, but
Right.
targeted.
But we all know every complaint doesn't get Human Rights Act protection, right? So an
For sure,
argument
but not-
certainly
I'm
could
just
be
talking
made.
about sort of, taking
Yeah.
things out and not looking at them in context. Is that really how we do it?
I think you do need to do that to some extent. Now, I'm reasonable. I understand that the June, she calls it a mediation session. It was actually a counseling interview. So that means that Mr. Kaufman would not have been involved at all in that. That related to the May request. If the court were to determine that I keep calling it a request, it's a complaint. The May complaint, if that was a protected disclosure, you could probably that might relate enough to it, but that still gets you a 4-month gap and not any positive evidence. And that's what's key here. You still need positive evidence that for causation, even when you have temporal proximity, and we don't have that here. And I'll end with what I think is probably could end both the discrimination and retaliation. Any sort of causation link is that we need to remember that for the suspension, Kaufman was just the recommender. He recommended a 9-day suspension. That then went to someone outside of the chain of command, Lynn Person, who reviewed appellant's response to that. She also reviewed all of the other sort of requests that were made in that division. And what she found was appellant was unique in both the quantity and duration of the delay in these requests, and that no one else had anything comparable. And this court's Furline and Hamilton cases talk about the fact that when you take the decision maker out of that chain, then the causation link, to the extent there is one, is gone. And we have that here. If you just bear with me to check my notes to make sure. I believe that's all, unless there's other questions that the court has.
Ready.
Thank you. We would ask that you affirm.
Thank you, counsel.
First, I'd like to address the question posed by the court on whether a comparator is required. And it's clear, and there's a definite law, EEOC law before the commission, that a comparator is not required, that a discrimination case can be made without a comparator. And I don't understand the district council's position that this issue of any type of animus not being litigated before the court, before the trial court. That certainly is not the case. Her deposition was taken. She would have stated at her deposition or been asked at her deposition, why do you believe this was discriminatory? And then
I think their point is that that's not how you briefed it. I mean, maybe it's also, their point is that's not how you tried it, but it's also not how you briefed it to this court. The focus was on the comparator, not.
Well, yes, what I heard counsel say was that it was not litigated before the trial court. And
Well, they're two separate problems, I suppose. Preservation and then, failure to actually argue the issue to this court.
and the next, well, so just to finish that point. So our position is that it was presented, was litigated before the trial court. The next point was whether any type of implication can be made from the fact that the supervisor here, Mr. Kaufman, recommended the proposed suspension, but was not involved in the suspension. There is a case that was decided by this court a number of years ago. It's Pula v. Howard University. And this was dismissed on a motion to dismiss. And the court reversed that decision and found essentially that an implication could be made against that the supervisor had knowledge of the EEO complaint. Let's see. I think those are all the points that I wish to make.
Did you manage to find the email that you had referenced that, like, you opposing counsel, I do not have any independent recollection of being mentioned or seeing in the record?
I did not see it. It's in my notes from my client with the reference to the record. I don't have a specific site that I can place in the record.
Got it.
Thank you.
Thank you, counsel. We appreciate your arguments today, and this case will be submitted.
All rise. This honorable court is now adjourned